Okay, dear speakers, colleagues, participants of our today's international seminar, let me start. First of all, thank you very much for joining us. The topic of the seminar is EU standards on effective judicial protection and judicial independence, which is conducted and organized by me and by my wonderful colleague from Jagiellonian University, Professor Monika Florczak-Wontor, within the framework of our research project, Rule of Law and Independent Judiciary, Major Challenges for Ukraine and Poland in the context of European Union integration, which is supported by the Foundation for Polish Science as part of the For Ukraine program. So we have invited 4 distinguished speakers from Poland and Ukraine who will present certain aspects of this topic within the area of expertise. Each talk lasting approximately 15 minutes. And after this, there will be a discussion moderated by Professor Monika Florczak-Wontor. Also, you will have, during the discussion, there will be an opportunity to ask any questions and also express your own opinion, maybe reflect on some issues. And just to remind that our seminar will be recorded, and also it will be published, the recording will be published on the official site of our project. I'd like to express special gratitude to our brilliant speakers for accepting the invitation and taking the time to share your knowledge and experience with us today. We really appreciate your involvement, and I think that this is very valuable and important, especially nowadays in such a difficult time and circumstances for both countries, for Ukraine and Poland. And I believe that we need to unite our efforts in the joint struggle for the rule of law and access to independent and fair justice as one of the key elements of the rule of law in practice. In fact, fortunately, we have no other alternative, since if we want to be a part of a free and democratic Europe, we must meet these requirements. So just not to take off time from our dear speakers, I would like to invite the first speaker, namely Professor Nina Półtorak. She is a professor of European Union law at the Jagiellonian University, as well as a judge at the General Court of the European Union since 2016. Also, Professor Półtorak was a director of postgraduate study programs in EU law at the Jagiellonian University, as well as a visiting scholar at the University of Oxford and at the European University Institute in Florence. She was admitted to the Krakow bar in 2000 and also she worked as a judge at the Regional Administrative Court in Krakow and was seconded to the Supreme Administrative Court of the Republic of Poland. And also Professor Półtorak was a director of the EU Law Department in Supreme Administrative Court. So the title of today's speech is EU Standard on the Right to a Fair Trial. So, dear Justice, the floor is yours. You're welcome.
Thank you very much. I hope that you hear me and you see me. Great. Great. Thank you very much for the introduction, and thank you very much for having me here, inviting me here. I'm really glad to have this opportunity. And of course, also I have the privilege of being the first speaker, so I can give some kind of more general or the view, the general view, overview of the topic of the access to the court or fair trial in the EU law. I will try not to abuse my time and not to abuse this privilege of being the first one, but I will just try to point out few things, few issues that I think are important in this field. And of course, later on, I understand that there would be more speakers talking about more detailed topics. So Right now, of course, the standard of the fair trial or the access to the court in EU law is a standard that is codified in both the preliminary in the founding treaties and in the charter, but we should take a step back and to see at to the history of fair trial and the effective judicial protection in the EU law, because I think that without discussing this history of this general rule of the European Union law, it's more difficult to understand what it means now. So when we look at this history, genesis of the general principle of the effective judicial protection in the EU law, we can go as far as to 60s of the last century, when the Court of Justice issued some judgments concerning the effectiveness of the EU law, the effet utile of the treaty, as the Court of Justice was saying, stating that the member states, they cannot undermine this effectiveness of the EU system. Then we had the judgment, which is right now very important one, and from which the history of the rule of law in the European Union started, which is of course the judgment of 86 of Lever case, where the Court of Justice, referring to the EU legal system, stated that this system is based on the rule of law, and the constitutional, and the treaty is the constitutional charter of the EU law. And then the Court of Justice stated that this is a complete system of legal remedies, and within this complete system of legal remedies, the Court of Justice is able to review all the acts of the EU EC at this stage institutions. And then we have judgments which concern the legal systems of the member states, and here we have the judgments of von Colson, Hart, where the Court of Justice started to use the phrase of the effective judicial protection. At this stage, it referred to the sanctions that were offered in the legal system of the member states. But very soon, in '86, the Court of Justice referred this phrase "effective judicial protection" to court procedures. So that was in Johnston or Haylen's case. And at this stage, the Court of Justice stated that this effective judicial protection rule is a general principle of the EU law, and it is derived from the legal systems of the member states, constitutional traditions of the member states, and of course from the European Convention on Human Rights. So here we have the bottom-up development when the Court of Justice based its case law on the constitutional traditions of the member states, and on this basis established a general rule that we still have in the case law, and right now we have also in the treaties. So many years later, we have this current standard of the right to court and the fair trial, and this standard is enshrined starting from Article 2 of the Treaty of the European Union. So the rule, the principle, the value of the rule of law. As you know, the Court of Justice uses Article 2 and especially rule of law as a kind of general value, general rule that from which we can right now derive also the details about the independence of judges, the details about the right to court in general. And the Court of Justice is stating that that Article 19, which is also right now stipulating the standard of the judicial review, Article 19 of the Treaty of the European Union gives concrete expression to the value of the rule of law stated in Article 2 of the Treaty of European Union. And Article 19 of the Treaty of the European Union, which right now is the most important probably provision used by the Court of Justice in the case law concerning the right to court, right to independent court. This is a provision that is nothing new in this sense that it only repeats what was already stated in the case law before. And we know that Article 90 states that, first of all, it is for the Court of Justice to ensure the proper interpretation and application of the treaties, and that within this application and interpretation, the law is observed, meaning the law, general principles, and international law, and all the general principles of the law that should, even if not codified, should be found in this EU legal system. And of course, we have this another phrase that is right now so popular in the case law of the Court of Justice, which states that member states shall provide remedies sufficient to ensure effective legal protection in the fields covered by the EU law. As I said, this is nothing new. It is only kind of codification of the case law that already existed before the Treaty of Lisbon, when Article 19 was formulated in this sense. But this codification occurred to be very, very important for the development of the case law. Then, of course, we have the Charter of Fundamental Rights and Article 47 of the Charter within the title Justice, which says about the details of the standard of the judicial protection in the EU law, and it states that everyone is entitled to a fair public hearing within a reasonable time by an independent and impartial tribunal previously established by law, and there is additionally the right to being advised, defended, represented, and the right to legal aid. There are also other provisions in the Charter which might be of interest here, like presumption of innocence, like the right not to be punished twice, etc. But we don't have time to go into the details. And now, what is the difference or the relation between Article 19 of the treaty and Article 47 of the Charter, which both deal with the effective judicial protection? According to the Court of Justice, and that was already stated in the famous case law of the Portuguese judges, but is repeated in also all the Polish cases where the right to independent judge is involved. According to the Court of Justice, the principle of effective judicial protection, which stays in the EU legal system as a general principle, is referred to in Article 19. So Article 19 of the treaty refers to the effective judicial protection. But this effective judicial protection is now reaffirmed by Article 47 of the Charter. So that is the relation according to the Court of Justice as the substance of those provisions. As the procedural difference, we know that it's very important when we can apply Article 19 and when we can apply 47. Article 19 we can apply in every fields covered by the EU law. That means that when the national court is a court that can deal with the cases covered by the EU law, Article 19 can be applied, is applicable. That means that the given case in which we check the standard of the effective judicial protection, of the effectiveness of the independence of judges, this given case does not have to be a EU case in order to apply Article 19. But when Article 47 of the Charter comes into play, according to Article 51 of the Charter, it might be applied only if the member state is implementing the EU law, which is, of course, a narrower field of application than Article 19. And as I'm sure you know, that the Court of Justice is often using Article 19 when the given case in which the question was asked by the preliminary question was asked by the national court was not really the EU case. and it is difficult to apply Article 47. Then, as to the standard of the access to the court, we have to ask the question if the access to the court to defend, to protect EU law is the right to access the EU court, meaning the Court of Justice, within this the General Court also, or it is a right to access the national court. And from the case law of the Court of Justice, it is clear that the burden of providing the effective judicial protection in the cases concerning EU law, this burden should be borne by the member states. So the access to the Court of Justice is, of course, provided, and the Court of Justice is a court that decides about the actions of the EU institutions. It also decides about the validity of the EU law. It decides about the interpretation of the EU law at the request of the courts of the member states. But this is not a court that is able to decide every cases that concern the EU law within the member states. And here we have the national courts that have to provide this effective judicial protection. And we know from, at least from judgment Jego-Kere from 2004, that it is for the member states to provide this system of the effective judicial protection of the remedies in cases concerning EU law. Then, of course, as we also know, the problem with the judicial protection offered by the Court of Justice is that the access to this court is limited, is restricted. The rules concerning the access by the individuals are very strict still, and the jurisprudence case law is not changing in this respect. Still, it's difficult. So again, this burden of access to the court lies really on the member states. And then, in very general manner, what is the standard of the judicial protection that the member states must comply with? First of all, and that would be subject to further discussion. First of all, the national court that is deciding the EU case must be independent and impartial, and that comes from Article 47, that is of the Charter, that is repeated by the Court of Justice in many cases. But that court must be also the national court that is deciding the EU cases. That must be a court that is able and competent to comply with the basic rules of the EU system. That means with the principle of primacy and the principle of effective judicial protection. And that must be the court that, as according to the Simmental formula from 70s last century, that must be the court that is able to ignore any rule of the national law that does not comply with the EU law, and that must be also the court that is able to apply the rules which comes from the EU law, but which are not provided in the national system. So that must be also a court which might be sometimes called to apply something that does not exist in the national law. In this respect, of course, I would like to underline that the Court of Justice in the last case concerning the claim against Poland, Commission against Poland, which concerned the problem of the disciplinary procedures and the so-called muzzle law of Poland. In this case, the Court of Justice stated very clearly that the member states may not invoke the rules concerning the effective judicial protection and judicial independence requirements as a rules which might be against their national identity. So the Court of Justice stated it's not like this, that what is required by the EU law from the member states concerning independence of their judges, concerning the procedures that they have to offer to enforce the EU law, that those rules might be against the national identity of the member states. That was excluded and clearly stated by the Court of Justice. And finally, of course, we know that the national law and national institutions, they can rely on the principle which is called the principle of the judicial and institutional autonomy. So, of course, the member states may design their judicial system and their procedural system in a way that they wish. So they are autonomous in this respect, of course, until there is no, unless there is no the law which would stipulate some rules or some provisions which would come from the EU system. So they are autonomous, but of course this autonomy is limited. Is limited by two conditions. First condition, which is the principle of equivalence, so they cannot provide for less favorable rules to execute the EU law than those which govern the similar domestic actions, and the principle of effectiveness. So whatever the member states provides in their procedural law must not render impossible or in practice or excessively difficult the exercise of the rights conferred by the EU law. And these two rules, they are subject to extensive case law of the Court of Justice. There are more and more cases where the national courts are asking questions exactly about application of those two rules. And we, of course, don't have time to go into details because it is so detailed and so case by case related or based case law. But what comes from this case law is that, again, first of all, the national courts must be able to verify the EU law, verify the national law in view of the EU law as to the procedural rules. They must be able to ignore some rules of the national law which are not in compliance with those two principles, and sometimes they have to even invent some solutions which are not provided in the national law. So, to sum up, this standard of the judicial protection, the standard of the fair trial, that involves very conscious court, national court and judge that has to really verify the national law as to its compliance with the EU law and to comply with the rules of effectiveness, equivalence, the rules of the primacy, the rules of direct effect, etc. But first of all, that must be an independent judge and independent court. Thank you very much.
Thank you very much, dear Justice. It was really very interesting, and I think that we will come back to some points during our discussion. Yeah. So the next speaker is Tomasz Tadeusz Koncewicz. He's professor of European Union law and also director of the Department of European and Comparative Law at the University of Gdańsk. And he's member of the editorial board of the Oxford Encyclopedia of EU Law and member of the Council of the Foundation Jean Monnet pour l'Europe in Lausanne. Also, Professor Koncewicz is an attorney specializing in the strategic litigation before supranational and constitutional courts, and also he was principal investigator at pan-European research projects and has taught and researched across the world, among others. It's UC California, Berkeley, Princeton University, Radziner Law School, and also European University Institute. So dear professor will give a speech entitled on the first principles of the law of integration, the rule of law, and the social legitimacy of courts in times of constitutional reckoning. So dear professor, you're very welcome.
Thank you very much for those very kind words of introduction, and I'm very, very happy and privileged to be here. So, by way of a short introduction at the level of framing my arguments will fall into 4 major parts. First of all, I want to frame the discussion and ask the question, instead of what the court says, why the court says what it says, because the trajectory from the all too often and very traditional what the courts say is often front and center, and the basic and the most important question in my mind is why the court is saying what it's saying about the rule of law and the judicial independence. Secondly, I want to point out that we are now faced with a completely new normative context in which the court is developing its case law on the rule of law and judicial independence. Thirdly, I want to point out a few lessons from the constitutional capture that has happened in Poland, which is of relevance not just for Poland, but for Europe and beyond. And finally, and more provocatively, I want to challenge you to think about the rule of law and judicial independence by going beyond lawyers' heads. So lawyers all too often focus on right here, right now, which I call the boats. And by focusing on the boats, we forget about what the destinations. We forget about the journey. So what are the boats in 2023 that we might simply restate, and we should move on? So we know that Article 19 and Article 2 of the Treaty on the European Union, as excellently pointed out by Judge Półtorak, they express the value of the rule of law, which is defined by reference to effective judicial protection. Judicial independence serves as an essence of the fundamental right to fair trial. Article 19 of the treaty is a constitutional basis for the shared judicial mandate of both the Court of Justice and the National Court, and so forth and so on. So those are the boats. Those are the elements that form the part of what question. But I want to focus on the journey. I want to move beyond the boats and ask the question, why? And there are 2 elements to my argument why the question why is absolutely crucial for Poland, for the European Union, and for the Ukraine, for that matter. There are 2 elements. The first element is the European consensus. What do we mean by the European consensus when we say that Europeans are still together and are still ready to paddle together despite all the differences and disagreements? Despite the common knowledge and the conventional wisdom, European consensus is not a perfect consensus. It has never meant to be the perfect consensus. Why? Because the member states are not perfect. So rather than framing the discussion in terms of the consensus that is perfect, we should rather stick to the language of overlapping consensus. Overlapping consensus among the European peoples assumes that there are disagreements between us, that there are disagreements that will be ironed out within a common framework, within a common platform that the EU provides. And what is most important for the overlapping consensus understanding is there must be a certain core that is binding on all actors participating in the European public space if the European Union is to survive. And this core of the overlapping consensus is not only binding on all parties to the consensus, but must be enforced equally against all the member states and other actors that take part in the European public space. So the argument that I'm trying to make out here is that the rule of law must be part of this overlapping consensus that has brought states together and that has allowed the European Union to move forward on the assumption that there is a core understanding of what the rule of law entails for all the actors participating in the European public space. This is absolutely crucial. Second element, other than the European consensus, that really alludes to my why element is we have to understand that the rule of law, judicial independence, as important as they are only part of a grander narrative that frames the votes. What is the grander narrative that the rule of law and judicial independence form part of? So first of all, I call this grand narrative a narrative of first principles that really explains in axiological terms where to locate the rule of law and why rule of law plays such a prominent role. We don't have time to go into details. I will be happy to share the presentation with you afterwards, but there are certain elements that really stand out. So learning from the past, member states have been always meant to be member states bound by the rule of law. First principle of never again constitutionalism, that assumes that constitution was to be the supreme law of the land, that fundamental rights were supposed to be a check on the political power, whoever is at the power at any moment, whether it's rights, left or center. Fundamental rights are to be protected in a transcendental way, so to speak. Separation of powers, and finally, supranational adjudication. Those four elements make up of what I call never again constitutionalism. And on top of that, the rule of law frames this never again constitutionalism by saying that every political power within the European public space must be a political power constrained by law. So who's the enemy then? If you have the narrative of first principles and the overlapping consensus that assumes a commonality that is non-negotiable, what is the counter narrative to all this? I call the counter narrative that is right now taking root in within the fabric of the EU law, politics of resentment. And there are certain elements that strike at the very heart of the first principles. You have a narrative around first principles, and you have a counter narrative on the other hand, defined by the politics of resentment. And let me just mention a few of the elements that define the politics of resentment. There's a new understanding of the rule of a constitution. Constitution is not to protect subjective rights. It is simply to express the uniqueness of the state. The law equals the will of the majority. Constitutional court is not there to provide a check on the political power. It has become, and it is becoming, an enabler of the political power. And the rule of law, and most crucially, it no longer frames the decision-making process, but rather it facilitates the expression of the will of the people. The will of the people takes center stage and often pushes the rule of law to the backstage. This is absolutely crucial, and this is something that we have not anticipated in 1989. So what are then, if you have the clash of narrative and the counter narrative, what are the fundamental lessons from the constitutional capture that has happened in Hungary and Poland, when you have the politics of resentment providing a new justification for the political process at the domestic level, which then spills over into the European politics. So we have to, first of all, the most fundamental lesson for Poland, Europe, and in Ukraine in the long term is that when you speak about the rule of law, you really have to ask a more fundamental question, a first order question. What is the legitimacy, the social legitimacy of the courts that are supposed to be the bulwark of the rule of law? And if you really want to capture the essence of the rule of law, you have to understand social legitimacy as a property, perception, and process. Property. Social legitimacy of courts obtains when the court is legitimate not because of its formality, but because of the trust and faith of the court by the public. That is a property, that is a part of the social legitimacy discourse that we badly need. Perception. You have to build a feeling of common cause beyond the self-interest. If you really want to build a social legitimacy for courts, you have to build a practice of the rule of law, and to build the rule of law from the ground up. Social legitimacy finally as a process, it is not a given, but a variable. It is something that builds over time as a result of renewal and practice. Social legitimacy of courts as a process does not happen overnight, but it is a function of history, culture, education, legal tradition of any given country, and it is a process of becoming a social legitimacy. So this is absolutely crucial. If you have those three elements that builds social legitimacy of the courts, then you can ask a second order question. Second order question, which misleadingly is often taken by lawyers as a starting point. Wrong. A second order question is, once you know what social legitimacy is and what are its components, you have to ask the question, what, how, and why the judges should be doing in 21st century in order to gain social legitimacy, so understood. And you have certain elements that speak to my second order question. First of all, you have to understand that social functions of the courts is always to be understood at the service of the citizen. You have to refocus the perspective from the negative to the positive. It is not only what judges must not do, but it is equally about what judges must do in order to be judges in the eyes of the public. You have to move beyond the formalism. So courts of law, not courts of statute, because the rule of law is never about a statute and statute alone. Rule of law is about a lived practice of the rule of law, how people relate to the statutes as applied and interpreted by the courts on the ground. Secondly, you have to embrace the challenge of new self-perception of the judges. Independence of the judges must go hand in hand with the accountability. More power judges gain, more responsible they must be to the public. And I will come back to this in a moment. Thirdly, you have to learn how to bridge the gap between the growing expectations among the citizenry as to what the justice should be and how the justice should be served, and the quality of performance. We have to ask the question, what the judges are doing with their immense power that they have been given, and this incredible trust that we, the citizens, put into judges. So fourthly, if you want to answer adequately the second order question, what and how the judges are doing, you have to understand how the law has changed. Law today is a conflict. Law is situational. Law is contextual. Law must be seen as effective. We need more law and less law understood, limited to statutes, because only a combination of text and good practice will in the end build a legal standard. And it is the legal standard that will build in the end the social legitimacy of the courts. We have to transition from a right to court, the element of access, to a right to good judge, a term that springs evidently now and then in the case law of the European Court of Human Rights. Good judge, a perspective of a good judge, it is a procedural quality of the right, not just access to a judge, but what happens once you have the access. Importance of public perceptions. We have to move beyond the disarming logic. Everyone is guilty but me. With great power comes even greater public scrutiny, because if we understand properly what Montesquieu has said, it was not just la bouche, but Montesquieu used on and on and on the term puissance de juger, power to judge, power to adjudicate. And with this great power comes great responsibility. And finally, and I will finish here, what are the elements of this going beyond the lawyer's head's trajectory? First of all, a lesson from Poland, from Hungary, for all the member states of the European Union, and for Ukraine as well. is that we have to understand the inherent limits of the law, because there's a distinction between the law, the role the law can play in democracy building, which is unquestionable. But what about democracy sustaining? Democracy will be sustained long-term when the rule of law is translated and is becoming a living practice on the ground, because institutions, as we have seen in Poland, can only do so much. The constitutional courts do die in loneliness if they are not supported by the public understanding of what the courts actually are doing. This is so because even the strongest institutions must fail if they are not supported by the citizenry. This is the most tragic lesson from the capture of the Polish rule of law for the EU and also for Ukraine moving forward. When does democracy become the only game in town? It becomes the only game in town when the social and institutional engineering is translated into the behavioral register, because the habits of heart of the citizenry will always work as a necessary complement to well-designed constitution. Constitution without the habits of heart will be just a piece of paper. Sustaining constitution long-term calls for engagement, education, and also awareness of why and what the institutions are doing for me as a citizen. So the embedding social function of courts, and I'm really about to finish here, is to translate the constitution from their constitution to my constitution first, from a court that is anonymous to my court that protects my constitutional rights, from a judge to good judge. And then in the end, you give yourself a chance of obtaining a law with the human face. And finally, when I was preparing for this presentation, I reminded myself a conversation I had with the former president of the Israeli Supreme Court, Aharon Barak, and he told me, Tomasz, judging has been always a slavery for me. It's a slavery of special kind, because he said, as I sit at trial, I always stand on trial. I have to accept that at some point I will be judged by those who come to me for legal protection. And finally, justitias vestras judicabo. That was the exhortation at the entrance to each court in the old Poland in the 16th, 17th, and 18th century. One day, your justice will be judged, justice. And this is the key to not only unlock the huge reformatory potential of the rule of law, but also to make sure that any future constitutional capture will meet its most ardent defender, an engaged citizenry. And this is the kind of discourse we all need to make the rule of law dots finally connect with the top-down process with the bottom up, because at the end it is all about the habits of citizens' hearts. So thank you very much.
Thank you very much, dear Professor, for your very meaningful and deep presentation. And we're going further. The next speaker is Professor Piotr Bogdanowicz. He's professor of European Union law at the University of Warsaw, Faculty of Law and Administration, where he lectures on EU law, including EU public procurement law. He is an author of several books and articles in leading journals, and also Piotr is a qualified Polish legal advisor and has been recognized for years by the Chambers Europe and the Legal 500 directories as a leading individual in public procurement law. And also Professor Piotr Bogdanowicz is a former advisor to the Polish Constitutional Court. And today, Professor will deliver a talk dedicated to the topic of independence and impartiality of courts and judges in the case law of the Court of Justice. So, dear Professor, the floor is yours.
Thank you very much for having me here. Indeed, I will focus on the independence and impartiality of courts and judges in the case of the Court of Justice, which at the very start must mean or must constitute a disclaimer on my side that within this 15 minutes, it will not be possible to make an overview of this case. So I will basically focus on specific points only. And the agenda of my presentation will be as follows. So basically, I will start from the notions of the independence and impartiality very briefly. Then I will present the change that was made in the case law of the Court of Justice since 2015, when Law and Justice started its so-called reforms in Poland, to show not only how it changed the quantity of cases concerning the rule of law before the Court of Justice, but also its quality. And by quality, I mean eventual focusing on the rule of law and not other issues in the case law. Of course, I don't want to focus on those bad boys as Poland and Hungary only. So I will try to show that the problems with case law are also present in some other member states, and I will show some cases. But of course, we should not even try to compare Poland and Hungary to other member states in terms of the collapse of the rule of law. And then two last points will focus on forms in which the rule of law is protected. So I will show that there are some actions that are brought by the European Commission, which did a lot to preserve and to protect the rule of law in Poland, but also, and I will try to show it as well, its inactivity, its inactions resulted in some problems. And then I will show also the examples of preliminary references from Polish courts, and I will end up with showing that not only judgment but also some orders were aimed at the protection of the rule of law in member states by the Court of Justice. As regards independence and impartiality, these are the terms which, for example, in Polish constitution are differentiated. So basically, independence refers to courts, impartiality to judges. In the case law, the Court of Justice sometimes does the same. So basically, differentiates between these two notions. Sometimes it treats them as something common. Nonetheless, it says that, and this is the case law which did not appear just in 2015 or a few years before, but it's much older. So that this constitutional requirement that the courts have to be independent has two aspects. One is external, which basically relates to the lack of hierarchical, the lack of hierarchy above the judges. So basically, that they cannot receive any orders or instructions that may impact the decisions or judgments. Of course, it does not mean that the administrative supervision cannot exist. It can, but again, it cannot impact the fact that the judgment has to be independent. The second aspect is internal and is linked to impartiality, which means that there must be a proper distance between judges and the parties, no relationship which may again impact on the objectivity or any interest in the outcome of proceedings on the side of the judges, and these notions, these guarantees comprise, as the case law of the Court of Justice shows us, a number of factors. Here are just exemplary ones. Basically, an independent court means a court where guarantees regarding the composition of the body or the appointment of judges has to be ensured, length of service, and I will get back to that in a while, showing some examples, grants for withdrawal, but also, for instance, carrying out disciplinary proceedings. And again, it's not the case that no disciplinary proceedings are possible, but a set of standards has to be observed in this very sensitive case. And the second element of this guarantees, which is a little bit more subjective, but basically it relates to dispelling any reasonable doubt in the minds of society, of individuals, as to the imperviousness of a court to any external factors. So let's look how these guarantees were protected by the Court of Justice. And as mentioned, there is a radical change since 2015, which is shown in terms of first of all, quantity of judgments before the Court of Justice. Here is just a Polish example. In 2015, there were just 15 references from Polish courts brought to the Court of Justice. None of them related to the rule of law. In 2020, which set a record in terms of the number of preliminary references, where there were 41, approximately 70% of them concerned rule of law. But I think the even more important thing is the change of quality, which may be seen on the examples of two cases. The first one, a Hungarian case concerning the law that forced judges to retire earlier. So basically, the retirement age was shortened. A very similar case to the one that was brought to the Court of Justice by the Commission a few years later about Polish law. But what was important in this 2012 was the fact that the case was not resolved on the ground of the rule of law, but anti-discrimination directive only, which means that even if the commission, let's call it like that, won the case, it need not change anything with regard to the situation of of judges that were forced to retire because, for instance, just paying them the compensation was enough from the perspective of this judgment. So basically, Hungary did not have to get them back to court. Whilst the Portuguese judges' case that was described by Professor and Judge Półtorak showed the importance of the rule of law and thanks to this judgment, the aforementioned case of the Commission against Poland concerning the shortening of retirement age was basically possible. There was no coincidence. The European Commission brought the case shortly after this judgment. As mentioned, the case law on the independence and impartiality does not refer to Poland or not only to Poland and Hungary. Unfortunately, Poland sets the record here, and these are just very few examples, just different cases. The Commission against Poland was the one that I already described. AK, the case was the one in which the Court of Justice for the first time said that basically such a body as a disciplinary chamber of the Supreme Court does not meet the conditions set forth by Article 19, presented by which has already been presented by Judge Półtorak, and basically showed that a body like the National Council of Judiciary does not meet EU standards either, whilst Wójt case was a very important one because it basically gave a chance to see judgments that were issued by courts and the judges that were appointed wrongly as potentially null and void. But as said, there are also different member states which struggles. Hungary is, of course, an obvious case. The one presented basically required that or prohibited a sole assessment by the court of potential incompatibility of Hungarian law with EU law, and basically forced them to bring the case to Supreme or Constitutional Court, which obviously have already been unfortunately taken over by the executive powers in Hungary, and there was no surprise at all. The Court of Justice said that this Hungarian law was illegal. Maltese case, Republika, is another interesting example, because basically it shows that if or as long as such a body as National Council of Judiciary is impartial and participates in the process of appointing judges, then a sole fact that judges are appointed by the representative of an executive power, like in that case that was the Prime Minister, is not necessarily a problem. And this case is important also because this element is important because Polish politicians, Polish authorities often like to complain that that basically Poland or Hungary are being discriminated in the European Union because there are other similar situations in other member states, and the European Commission does not react. This case or Romanian case shows that the Romanian case was a primary reference, but basically it's not the case, and one of the examples might be a very recent reaction of the European Commission on the situation in Spain regarding this National Council of Judicial or similar. But the European Commission, as we know, brought a number of complaints to the Court of Justice. Again, here are just a few examples. There are more infringement proceedings carried out by the European Commission. The main issue with some of them was unfortunately timing. Here are two examples thereof. The case regarding the disciplinary chamber in the Supreme Court. The judgment itself was issued nearly after 2 years, and in the meantime there were several motions from the national prosecutor to strip the immunity of judges. But even a bigger problem is the case concerning the so-called infamous Muslim law, because the law entered into force in 2020. The judgment was issued after 3 years only. The action was brought after more than a year. So basically, the outcome of these judgments was not surprising at all. But again, the timing was not the most fortunate. Even if, and that must be emphasized, and I will finish here. The Commission applied in this infringement proceedings for interim measures in a very different form. So, for instance, in case Commission against Poland concerning the shortening of the retirement age, that was just a suspension of national measures, and even further, because the consequence of suspension of these national measures that were not in line with EU law meant that provisions that have already been repealed by Polish authorities had to revive. And I think that the most famous example of interim measures, the case concerning Muslim law, in which a periodic penalty payment was imposed on Polish authorities in the amount of €1 million per day, which resulted in unfortunately of the payment of hundreds of millions euro by Poland, and the case which unfortunately did not result in immediate repealing of this infamous act, which, and that is the last point for me, shows the biggest challenge with the respect of the rule of law. So basically, how to convince a member state which does not want to protect the rule of law that it should do so. Thank you very much.
Thank you very much, dear Professor, for a great overview of European Union standards on independence and impartiality of courts. I'm sure that we will discuss it in details during our discussion. And finally, our last but not least speaker, Dr. Oleh Petryshyn. He is PhD in law, senior researcher and academic secretary of the Scientific Research Institute of State Building and Local Government of the National Academy of Legal Sciences of Ukraine. His research interests focus on the European Union law, human and civil rights at national and local levels, rights of internally displaced persons, and maintaining the rule of law and constitutional governance during martial law in Ukraine. He has contributed to numerous publications in Scopus and Web of Science index journals and received the 2021 scholarship commemorating the Revolution of Dignity and the Heroes of the Heavenly 100. Dear Dr. Petryshyn will deliver a talk dedicated to the topic of balancing European fair trial standards with socio-political and cultural realities in Ukraine. So, dear doctor, you are very welcome.
Thank you, Christina, for such quite a presentation introduction. I would also like to thank the organizers overall for the opportunity to deliver my speech to a wide audience and share my research and experience with such respectable legal practitioners and scholars. My report, or rather a speech, will focus more on the current situation in Ukraine related to the judiciary, including the mentioned aspects, but I will also present my reflections on some more intricate and unseen aspects of Ukrainian socio-political reality. Maybe somewhat less practical, but I hope you will find them interesting. I will try to keep it short and concise and provide food for thought. I also wanted to give a special note to Tomasz Koncewicz. Please excuse my possible mispronunciation on how his speech resonated with the issues observed in Ukraine related to the rule of law. Amazing presentation, yet the gap in perceiving the rule of law between Ukraine and Poland sadly is vast. I will mention this briefly in the final thoughts of my presentation. As an academic, I acknowledge that my discussions may occasionally extend beyond the immediate scope of the topic at hand, a tendency rather driven by the intricate and multifaceted nature of the current situation in Ukraine. I would like first to bring your attention to the devastating impact of wartime on the delicate fabric of justice systems in general. Armed conflicts unleash a chain of repercussions that erode the pillars of fairness, impartiality, and access to justice, leaving vulnerable populations grappling with legal limbo and a profound sense of injustice. One of the most immediate consequences of war is the displacement of courts and judges. The physical destruction of courthouses, coupled with the threat of violence, force judicial institutions to relocate or evacuate, disrupting the continuity of legal proceedings and severing access to justice for affected communities. In occupied territories, the very foundation of justice crumbles as the occupying power asserts its own legal framework. This abrupt replacement of the familiar legal system strips the population of their established rights and protections, leaving them vulnerable to arbitrary detentions, unfair trials, and a pervasive sense of legal helplessness. Armed conflicts in general also pose a significant challenge to the capacity and accessibility of justice systems. Infrastructural damage, displacement of legal personnel, and the loss of vital case files severely hinders the administration of justice. The backlog of cases accumulates, and the pursuit of justice becomes an arduous and protracted endeavor, particularly for those seeking redress for wartime atrocities. Moreover, wartime conditions compromise the integrity of fair trial standards. The establishment of military courts and tribunals raises concerns about the independence and impartiality, especially in cases involving civilians. There are numerous cases on that regard, and even those involving Ukrainian armed forces representatives, as you probably know about. And even if this problem is not that big for Ukraine yet, aside from very big in nature cases, there are already reported cases of violations in Ukraine concerning military and ex-military commanders with a political nature, like the Chervinsky case. If you're interested, very interesting case to study. The presumption of innocence, the right to counsel, and the right to present evidence are often disregarded, leaving individuals vulnerable to unjust convictions and a denial of fundamental human rights. Armed conflicts inflict irreparable damage on justice systems, undermining the rule of law and exacerbating human suffering. The displacement of courts and judges, the breakdown of justice systems in occupied territories, the reduction in access and capacity of judicial systems, and the erosion of fair trial standards collectively contribute to a climate of legal uncertainty and injustice. Let me now shorten it a little bit and focus on the specific case of Ukraine. Because in Ukraine, the ongoing conflict also has severely impacted the judiciary. Reflective of the impact of war on the judiciary in general, in Ukraine, the displacement of courts and judges across the country has disrupted the normal operation of the legal system, forcing many courts to relocate and abandon their territorial jurisdiction. The fate of court records and case files left behind in occupied areas also remain uncertain, casting a shadow over the administration of justice in these regions. Despite these formidable challenges, the judiciary in Ukraine has demonstrated adaptability and resilience. In response to the mentioned challenges and prior due to the COVID pandemic, the Ukrainian judicial system has embraced virtual platforms, enabling court hearings to proceed despite the physical constraints imposed by the war. Video conferencing technology has become a lifeline, essentially, ensuring that parties to legal proceedings can continue to access justice even in the midst of conflict. This shift to remote hearings has been met with mixed reactions, actually. On one hand, it has undoubtedly allowed the judicial system to maintain a degree of functionality, preventing a complete breakdown of justice in the face of adversity. It has provided a lifeline for litigants seeking resolution to their legal disputes and has ensured that the wheels of justice continue to turn, albeit at a slower pace. On the other hand, the adoption of video conferencing technology has also raised concerns about access to justice and preservation of fair trial standards. The lack of reliable internet connectivity in some areas, particularly in conflict zones, can hinder the participation of parties and witnesses. Additionally, the virtual nature of these hearings can make it more difficult and challenging for judges to assess the credibility of witnesses and gather relevant evidence. Despite these challenges, the use of video conferencing technology has undoubtedly played a crucial role in upholding the rule of law and maintaining access to justice in Ukraine during wartime. It has demonstrated the resilience and adaptability of Ukrainian judiciary and its commitment to upholding the fundamental principles of fairness and impartiality. To mitigate the disruptions caused by the conflict, the Supreme Court of Ukraine has invoked emergency procedures, reassigning cases and adjusting court jurisdictions as necessary. These measures aim to safeguard the continuity of judicial process and ensure that individuals retain access to justice even in times of crisis. This resilience can be attributed to several factors, actually, including recent reforms within the Ukrainian judiciary, the unwavering support of the international community, for which we are always thankful for, especially to the people of Poland, for everything that you have provided for us. And also, an important factor is, of course, the galvanizing force of the existential threat posed by the conflict. These forces have compelled the judiciary to adapt and innovate, ensuring that justice continues to be served even in the face of overwhelming obstacles. In a stark contrast to the resilience exhibited by the judiciary in unoccupied areas, the justice institutions in Russian-occupied regions have suffered a complete collapse. Essentially, Ukrainian judges who remained behind faced intimidation, violence, and even imprisonment, while occupying force has imposed its own legal system. This dire situation further exacerbates the challenges faced by the Ukrainian judiciary in its entirety. As the conflict persists, the Ukrainian judiciary faces the daunting task of rebuilding and strengthening itself post-war. Significant financial resources will be required to restore infrastructure, implement legal reforms, and revitalize the justice system. International support will undoubtedly play a crucial role in this process. I also wanted to mention some specifics related to fair trial standards during wartime, because the specter of war invariably erects formidable barriers to upholding the fundamental tenets of fair trial rights. The presumption of innocence, the cornerstone of any just legal system, is often challenged as the presumption of guilt takes hold in the atmosphere of heightened security concerns. The right to legal counsel, a sacred pillar of due process, can be curtailed or even denied, leaving individuals to navigate complex legal proceedings alone and vulnerable. The ability to present evidence, the essentially lifeblood of a fair trial, is often obstructed by the chaos and destruction of war. Crucial case files may be lost or be inaccessible, witnesses may be displaced or too traumatized to testify, and physical evidence may be destroyed in the crossfire. This impediment severely hinders the pursuit of truth and justice, leaving both accused and victims yearning for vindication. The implications of the conflict on access to justice and fair trial standards are also profound. The displacement of courts and judges, coupled with the collapse of the justice institutions in occupied territories, has resulted in a significant reduction in access to justice for affected populations. Delving deeper into this realm, we should pay attention to the accessibility to justice for individuals affected by war, particularly in the context of civil and administrative legal instruments. Recent studies have shed the light on several pertinent issues that warrant our attention. Despite the existence of legal frameworks aimed at safeguarding the rights of war-affected individuals, procedural obstacles hinder their ability to seek protection through civil and administrative means. The complexities of legal procedures, often compounded by limited legal literacy, pose significant challenges for those seeking redress. A major hurdle lies in the practical impediments war-affected individuals face in initiating their judicial and extrajudicial defense opportunities. The displacement of populations, disruption of communication networks, and destruction of infrastructure severely restrict access to legal aid and representation, leaving individuals to navigate the intricacies of the legal system without any adequate support. And while procedural issues demand attention, the principal focus must be on dismantling the practical barriers that prevent individuals from exercising their legal rights and accessing justice mechanisms. The state's and academic collective efforts today must be directed toward bridging this gap and ensuring that the promise of justice extends to all, regardless of the devastating circumstances of war. In the final part of my presentation, which may be less scientific, I would like to address several issues related to Ukraine's European integration during the full-scale invasion by the aggressor nation. I will briefly delve into Ukrainian history, focusing on two key aspects relevant to my report. These being the challenges in perceiving and applying the rule of law principle and corruption, of course. My perspective in this section is obviously a personal reflection, not representing my institution's stance on this. Briefly, despite the centuries-old history of the rule of law from its early conceptualization in ancient philosophical thought to its evolution as a counterbalance to arbitrary power, the understanding of this principle in the Ukrainian context was significantly distorted, mostly by the predecessor state of the current aggressor, which continues its attempts to annihilate Ukrainians as a nation. Prior to Ukraine's current constitution, this principle was virtually absent and replaced by the principle of socialist legality, which, while superficially similar, only pertain to non-executive individuals lacking political power. For independent Ukraine, the rule of law emerged with its constitution, yet its full understanding was initially unclear, and even among scholars trying to implement it in Ukraine's legal reality. To quote Ukrainian scholar Viktor Smorodinsky, over 25 years ago, the rule of law was a sort of a MacGuffin for Ukraine and Ukrainians. If you're familiar with this term, you understand what I mean. This is something sought after as a solution to many problems, but with unclear understanding of how it functions and how it is to be applied. Years of academic debate and key Council of Europe documents later pretty much clarified its practical implementation mechanism. However, in Ukraine today, its application is still rare outside of the specific Supreme Court decisions, which, following European Union judicial practices, attempt to incorporate its checks and rules. This leads to the second issue, which is corruption, sadly a trademark of Ukrainian political agenda for maybe a couple decades now. A clear recent example is, of course, the top-level corruption in the Supreme Court during the war, which has already damaged the entire judicial system's reputation. Under the adverse influence of the aggressor state, Ukrainians tend to believe that even the war cannot alter the entrenched corruption situation. Ukrainians, while losing trust in the judicial system and the state, except possibly for the armed forces, turn to international judicial bodies like the European Court of Human Rights, which, according to recent statistics, along with media resonance, are top mechanisms for Ukrainian seeking protection for their rights, while speeding through the domestic judicial systems only to fulfill the European Court of Human Rights applicant requirements. However, due to the nature of the decisions of the European Court of Human Rights, many still fail to achieve enforcement of court decisions, as evidenced by the Ivanov and Burmich group cases. The increasing distrust and pessimism puts any possible future reform in danger. But looking ahead, not to be too pessimistic about it, the rebuilding and strengthening of Ukraine's justice system post-war emerges pivotal whenever it will end or come to a standstill, speaking of war. This will necessitate substantial resources for infrastructure restoration, comprehensive legal reforms, and international collaboration, of course, in which we are taking part even right now. These efforts are essential not only for reinforcing the judiciary's integrity and functionality, but also for ensuring that it effectively serves society needs. In the broader context of European integration, the challenges of implementing the rule of law and combating corruption are to be highlighted as key areas of future focus and present focus as well. Addressing these fundamental issues is crucial for building a democratic, just society in Ukraine, and is a testament to the nation's unwavering commitment to these ideals, even in the face of adversity, which was, in my opinion, proven in the resistance we are putting in today. My speech, therefore, serves as a testament to Ukraine's resilience and determination in the face of unprecedented challenges. It calls for continued support and collaboration at the international level, emphasizing that the journey towards a reformed, robust judicial system in Ukraine is not only a national endeavor, but a collective responsibility of Ukrainians and the global community in championing this case of justice and the rule of law. In acknowledging the dynamic nature of our world, particularly amidst the turmoil of war, it must be recognized that reforms, while aspiring for perfection, are inherently subject to the vicissitudes of their context. Even if past reforms in Ukraine have fallen short of ideal standards, my unwavering belief in the resilience and potential of Ukraine remains steadfast, firmly grounded in the conviction that its continuous pursuit of improvement is a noble and essential endeavor in these challenging times. And once again, I would want to thank all the organizers and all the legal scholars and practitioners present, and overall the people of Poland for providing support for Ukrainians. This was, I would just say, we wouldn't be able to survive without your support. Thank you very much.
Thank you.
Thank you very much. And thank you very much also to all speakers for the very interesting and very inspiring presentations. So many important issues were raised in your speeches, and I hope that we will return at least to some of the issues that were presented, and we will deepen our understanding of some of the problems that that were part of the presentation. So the presentation, as you saw, that the presentation cover different issues. Firstly, the issue of the right to a court as a standard of the European Union, and at the same time a standard of the independence of courts, impartiality of judges. But we also included the issue of the importance of social legitimacy of the court, the social understanding of the judicial function, and finally we have this Ukrainian perspective outlined, the issue of the adaptation of the EU standards to the Ukrainian reality, but also the great problems that are experienced nowadays by the judges, by the Ukrainian citizens, as well due to the war. So those are the issues that are on the table, and we can discuss around them. So I would like to invite you to the discussion. You can join the discussion traditionally by raising the virtual hand. You can write your question also in the chat, and I will read the question for all of us. And yeah, and I would like to encourage to also to make comments, observation, remarks, and I think that also not only question but also comments will be highly valuable for us for our discussion. It's always the problem of the first person. So if there are no volunteers, I can be the first one. And I've got a lot of questions, but maybe I will start with the first presentation and the question that will be for Professor Dina Półtorak. Because as we know, one of the sources of the right to a court is also constitutional traditions common to the EU member states, and you mentioned about the constitutional traditions. The EU standards are based on them. But at the same time, you mentioned that states have judicial and institutional autonomy. So they are free, and therefore this argument is also used by the Polish authorities, who have argued that the way the judiciary is shaped, the way the courts are organized, the way they function are matters that are part of the constitutional identity of the member states. And so the states not only have the right to decide these matters in their own, but they also have the right to defend their decisions. So this is my question. How can we indicate the limits for and whether there are some limits? I believe that yes, but there is a question where those limits can be found. In the case of the organizational structure of the courts, and whether what do you think about this argument that we have the traditional shaped right to a court, which is a part of our constitutional traditions, and it can be different than the right to a court, which is in the other member states of the European Union. So this is my question to Professor Nina Półtorak, but maybe we'll try to collect the other questions, and then we will come back to the speakers if you agree, just for the final answers to all the questions that will appear. So I think that the next one was our speaker, the next question, and then we have to other person who would like to address the questions. So, Mr. Petryshyn, you can, yeah.
Thank you. I had a question, surprisingly or not surprisingly, to another speaker, to Mr. Tomasz Koncewicz. I'm sorry again for probably mispronouncing your name. I found your presentation to be highly pertinent and resonating with my own thoughts on the subject. So I would like to ask you whether you envision, and if so, how do you perceive the transition of Ukrainian society towards your concept of understanding the rule of law and the role of the constitution and the judiciary, how you described it in your presentation? Do you see that happening? And what are the necessary requirements, prerequisites for this? Thank you.
Thank you very much. And the other question comes from Professor Hartwig, Matthias Hartwig.
Yeah, thank you very much. Matthias Hartwig from Germany, from the Max Planck Institute in Heidelberg. Thank you very much for the invitation, for the participation, and thanks to all persons having delivered here very, very interesting speeches on this very crucial topic, crucial for all states, but specifically, of course, in our times for Ukraine. I just would like to add, and this has already been mentioned in one or the other of these speeches. On the one hand, we have the structures and the procedures, and this is something which can be taught to a certain degree and can be amended via legislation. The other thing is a question of professional ethics. And this is within the head of all single judges. They have to change their mindset if they exercise the judicial profession. And I think there are, certainly in all countries, but in some countries to a greater degree, there are still a lot of deficits. And as you mentioned, you know, if we come to corruption at the Supreme Court, it shows and proves that there are still quite a lot of things to be done in order to develop a real professional ethics, which, yeah, sets limits, perhaps even more important limits than the structure and then the procedural prescriptions. You know, in Great Britain, for example, there is not the concept of a judge predetermined by law. It was not considered to be necessary in this country. Why? Because the judges were always independent, and this was a very long-standing tradition that judges are independent. It was not necessary to have this concept of a judge predetermined determined by law, which is a very
No, there are some
principle in continental Europe in many. Sorry,
no.
Do you hear me?
Yes,
Okay.
yes. Now, yes, it's fine.
Yeah.
Sorry.
And what I want to say is, to my mind, the development and the building up of a concept of professional ethics, which will be respected, strictly respected by all the judges who are in charge of these very responsible functions. This is the most important point in each and every country, and of course, specifically now in Ukraine. Thank you very much.
Thank you very much for the question. And Christina, you have the floor.
Thank you very much for great contributions. I have two questions. One question goes to Professor Tomasz Koncewicz. Again, you presented very deep presentation, and of course I have many questions, but I will limit myself only with one question. You mentioned about a right to a good judge as a procedural quality of a judge. So my question is it actually possible to establish in legislation this requirement of a good judge, or is it more the question of practice or something which is actually impossible to verify or to predetermine in any way? And I also would like to mention that in Ukraine, actually, we have introduced in the context of the reformation of Constitutional Court, we have changed the procedure for the appointment of judges to the Constitutional Court, namely in order to provide and guarantee the transparent procedure. We implemented such a specific authority as advisory group of experts, which actually consists of international legal experts, in particular from Venice Commission. And the main task of this authority is to evaluate not only professional, but also to conduct the so-called integrity check. So the moral qualities of judges in terms that judges must, in order to participate in the competition for a post of constitutional judge, every candidate must apply the so-called declarations of their assets, but not only declarations of private property and private incomes, but also the so-called declaration of relative ties. And actually, this advisory group will evaluate the not only professional qualities, but also the lifestyle of possible candidates. And I understand that probably this requirement was integrated specifically in Ukraine because of corruption. I don't know, there is no results. We will see if it will be efficient, actually. But my question, is it possible to establish and somehow verify these moral qualities of judges? And will it be enough to be a good judge, or it is a set of maybe other issues? And my second question is for Professor Piotr Bogdanowicz. Are there any possible ways to restore the rule of law in Poland nowadays? Yeah, because we know that probably the government will change, and I know that this crisis it's another topic for discussion. But is it possible somehow to restore this rule of law? And why actually I would like to ask why this happened in Poland, but I realize that maybe it will be very strong, very broad discussion. So I will limit myself only with this question: is it possible? Are there any legal ways to restore this rule of law? Thank you very much.
Mm-hmm. Thank you very much. I do not see, at least now, another question, so maybe I will give the floor to the speakers in order to answer the questions that were addressed to them. So maybe we'll start with Professor Nina Półtorak. Mm-hmm. Yeah.
Okay. Yes. Thank you very much for the questions and for the interesting discussion that we already have. Answering to the first question, so the question of Professor Florczak-Wątor about the national identity and the rule of law or the procedural autonomy, etc. So the Court of Justice is saying, and I think very rightly, and in accordance with existing case law, that of course the structure, the composition, the design of the national judicial system is the competence of the member states. So at the EU level, we don't have any specific rules how this system should be designed. So it is for the member states to design the system as they want. But designing it, constructing the system, they have to respect the values, the basic values of the European Union, which are enshrined in Article 2, and which are, of course, the values which are common values. They are taken from the legal systems of the member states themselves. They are not imposed by the European Union. They are values on which all member states decided to access the European Union. So within this within this discretionary power that the member states have about how to structure their judicial system, they always have to respect the rule of law. They always have to respect the independence of judges. They always have to respect other values that we have in Article 2, the human rights, democracy, etc. And even during this discussion, it was mentioned a few times that we have such different legal traditions. Member states, they have so many different solutions, measures, how to their judicial system functions, etc. The system of common law, Irish system, for example, is completely different than what we know from the Polish system, etc. We even look completely differently at the question of the independence of judges. And the solution that is accepted in a given legal system is completely not acceptable in other, because of different traditions, because different history, different mentality, etc. But what we have to respect always are the basic values. So the argument that were used by some member states, including Poland, saying that imposing on them an obligation to respect the independence of judges is against the constitutional tradition or the constitutional identity. This is something that is absolutely not acceptable, because of course whatever happened in Poland about the independence of judges was also very openly against the Polish constitution. It was not only that the EU law was violated by these attacks on the independence of the judges, it was also the Polish constitution. So there was no even a question about the constitutional identity. But even if there was, I mean, either if the member state tried really in a justified manner, say that some kind of requirements coming from the independence of judges is against the constitutional tradition, if it is really attacking the very core of the value of independence of judges, it must be changed. That's no question, because the values that we have in Article 2, they are the values that every member state should respect, must respect, and there is no accession and no membership in the European Union without accepting those values. And with this, I would like to draw your attention to something that was not underlined today, which is the concept of the European Union identity of the European Union as a legal system. So the concept that was introduced by the Court of Justice in 2022 in 2 judgments concerning the conditionality mechanism in 2 cases instituted by Poland and by Hungary. And the Court of Justice stated clearly there is something like identity of the EU as the legal system. The EU, and this identity is defined by Article 2, so values of the European Union. And the European Union is able to defend this identity. So it's not only that the member states, they might defend their constitutional national identity. Of course, they may and they can and they are competent to do this, but also the European Union is able to defend its identity, which is defined in Article 2. And again, I would like to, if I don't know how much time do I have, but I would like to refer to the presentation, very interesting presentation of Professor Koncewicz, who talked about those different traditions that we have also about the judiciary, how we understand the role of the judge, etc. Already in 2003, in an article of Derrida and Habermas, 20 years ago, it was said that the EU or the European identity should be based on the, as they said, la reconnaissance des différences. So that the EU identity, European identity, is really the identity that is based on the recognition of the differences between us, between legal system, between constitutional traditions, etc. But this cannot be a recognition that is not based on the common values. What we have in common, probably only what we have in common, is really are really the values, the basic values that we have in Europe. All the others we can design differently as still, if it is still in accordance with the basic values, we can do it differently. But those basic values are absolutely necessary. And just if I may refer to this discussion about the integrity and the professional ethics, which is also a very interesting discussion. Here, I have to start from my really deepest respect for the Ukrainian judges that are trying to, with this incredibly dangerous and risky conditions, they are trying to continue their service. Which is really like impressive attitude. Second, of course, the judges, they have to show their integrity, they have to show their moral values, etc. But all this would not be possible without the institutional guarantees about their independence. So the judge might be or should be a good judge only if he or she is really independent and there are guarantees about this independence. Guarantees, institutional ones, that do not require from a judge to be a hero. The judges must be very courageous, that's for sure. Someone that doesn't have the moral values, doesn't have the courage, enough courage, cannot be a judge, that's for sure. But we cannot expect from every judge to be a hero. And that they are heroes, and they proved it also in Poland when they were really like the resilience of judges in Poland is something that is impressive. But every system must provide for institutional systemic guarantees for judges to show their qualities, to show their moral and ethic qualities. So no moral values without the guarantees of independence of judges. Thank you.
Mm-hmm. Thank you very much. And now I would like to give the floor to Professor Koncewicz.
Thank you very much. This is indeed very, very interesting. And to follow up on Professor Półtorak's very pertinent remarks, I can only agree with her. My argument in favor of the overlapping consensus among the European peoples was just about this. There is a core that binds us together, and there is a core understanding of the rule of law who makes us who we are, Europeans. And overlapping consensus comes from the writings of John Rawls, and he was very explicit about excluding from the overlapping consensus those understandings from the parties to the consensus that are unreasonable. So what would be the example of an unreasonable understanding of the rule of law? Well, dismissing a judge by a fax. It is not part of the European legal tradition to dismiss judges like this, to make them subservient to the political power the way it has been done in Poland. That's simply not the common understanding of the rule of law practice as part of the overlapping consensus. Other than that, member states are free, because as Judge Półtorak was absolutely right, European law and European integration is just about about a disagreement as about it is about an agreement. So disagreement has been always written into the DNA of the European law, and the question is how to make sure that those disagreements that are there will not strike at the very core of the political community that the European Union is. This was just a follow-up to what has been said before me. So the two questions that were addressed at me really overlap. So I want to bundle them together and answer them as one. So last week I was at the EUI in Florence, and I spoke there on, that's the title of my presentation, Becoming a Lawyer. And I drew explicitly on what my good friend Professor Wyrzykowski once said, that it takes a lawyer to rebuild the rule of law. It takes a graduate of law to destroy the rule of law. So going back to your questions, you have to ask yourself a question: what kind of a lawyer you want to be? It really does matter what we say, what we do, and how we do, and how we say it in our daily life. Because every good change, and I really deeply believe in this, every good change in a society comes from me, comes from within. If I can talk to my friends, if I can talk to my neighbors, if I can talk to people who are within my professional reach, that Germans did not buy us out, the abortion has not been imposed in Poland, etc., etc. If I say something about the untruthfulness of all this, and I spread the news that there is a second different narrative, this is how I start educating people around me. I do not impose my views on the others. I simply give the others the opportunity to have another vision of reality. You know, I was teaching about the constitution all over Poland in tiny villages. Schools have been inviting me to come and talk to the students about what it means to have a right to a judge, what it means to have a constitutional court. And all those talks in those little towns all over Poland, let me understand one thing. People do need to know. They want to know, but they want to be shown respect by us lawyers, by actually packing and going there and telling them what it means to live under the constitutional regime, what it means to have a judge that is independent in our little town, etc., etc. We, the lawyers, have special responsibilities vis-a-vis the rule of law and the translation of the rule of law for the citizens. That's one of the most dramatic cautionary tales from the capture that has happened in Poland. We have been so busy, and it also goes back to your question, we have been so busy in the 90s with building the rule of law top-down that we have actually forgotten about the importance of translating the rule of law for the citizens, of translating the rule of law for their daily lives and making it a pertinent fact not just simply a distant institution in Warsaw that the Constitutional Court is, but how does the court matter to you right here, right now? What does it do for you? Once we get the message through, it will be the citizens who will be the best and most ardent supporters of the institutions, and they will be the ones who will protect the institutions against the future attempts at capture. So let me be very clear. There's no clear recipe, neither for Poland nor for Ukraine, what it takes to build a rule of law that is a lived experience. Because you can build new institutions, you can provide for fantastic procedures, etc., etc. But as long as those are not translated for the citizens, it will be like building castles on sand. It will take another Orban Kaczynski to come to power and just trash the system with the argument, those institutions have been not working for you, so now we will reorganize things so that the system will actually work for you. Those charlatans use the law against the law. You know, in the past, it was very simple. Democrats were for democracy and constitutionalism, and autocrats were against democracy and against constitutionalism. Today, Orban is in favor of democracy when understood in extra-majoritarian and arrogant terms. We, the majority, and whatever we decide goes as law. But democracy has been also about protecting certain rights and values in between the election cycles. It is not simply casting a vote that makes you a Democrat. It is also what you do after you cast a vote in between the election cycles. Whether you protect the rule of law, the independence of the judges, rights of the minorities, those criteria will make up your democratic fabric rather than simply casting a vote. What about, and I will be very, very brief here, what about the good judging? Yes, I agree. The independence and impartiality are absolutely crucial. But we must be, if we want to anchor the rule of law into the societal fabric, we have to ask ourselves those second and third order questions. What it means to be a good judge within your sphere of independence and impartiality. It means that you are ready to balance various values and rights, that you know what proportionality test will entail for your daily cases, for your docket, that you will be receptive to different arguments, that you will be ready to give people an opportunity to speak up at your courtroom, to defend themselves, that you will give them the right to judge. That is going beyond the institutional paraphernalia and really boils down to me thinking, wow, I lost the case, but I would love to go back to this judge again because he listened. He showed humility. He was interested in knowing what kind of arguments I bring to the table. And maybe next time when my arguments will be stronger, maybe I will win. But I want this kind of a judge to sit on my case. And the general takeaway would be there is no ready recipe for Ukraine, what kind of steps you have to follow in order to rebuild the rule of law after the war, and what you should do in order to anchor the rule of law. But one crucial thing would be to show engagement. We lawyers, we are not simply lawyers. We are citizens in the first place. And what has happened in Hungary, in Poland, has shown us that the law not only protects, that the law can be also manipulated, instrumentalized, that the law can be used as a tool to oppress. And once we understand that the paradigms have changed, and once we as lawyers show readiness to embrace the change and translate the change for our daily activities, for our daily language, which we use to communicate with the citizens, this is where we give ourselves at least a decent chance of reaching out to the people and really anchoring the rule of law within the societal fabric. But it will not happen overnight. It takes a generation to build habits of heart among the citizenry. It takes a day to build an institution. But the question, the real question, is how to anchor the institution within the society. That's a question that remains open. But you should ask yourself that kind of questions and be ready to face those questions head on.
Thank you very much for the answers and those additional thoughts and comments. And now I will go to Professor Bogdanowicz. Would you like to react for the questions that were addressed also to you?
Thank you. So it is possible to restore the rule of law. How to do so is of course a $1 million question, but I think that there are some basic rules that needs to be followed, and let me focus on two. So the first one is, of course, that it is absolutely necessary to in order to fix the rule of law, not to violate it. So basically, I'm very much against any solutions that are aimed at the restoration of the rule of law, and then say that there are some things that might be justified in this specific circumstances, namely that some minor violations would be possible. And the second thing is more specific, and then the answer depends on several factors. So, for instance, as regards the muzzle law, and basically bringing back EU funds to Poland, the situation is very straightforward and easy from what to do, but it's much more complicated, given that the draft law that was to some extent repeal the muzzle law, to some extent change the muzzle law, has been sent by President Duda to Constitutional Tribunal, which is not independent at all right now, and the Constitutional Tribunal for many weeks or months was unable to issue a judgment because the judges, because of the disputes within the tribunal. But it appeared that there is a hearing scheduled for this week, or for day after tomorrow, for Wednesday, and we'll see what it brings, because some grants against this new law that was to repeal the muzzle law might be legitimate. Some doubts concerning, for instance, the disciplinary proceedings ought to be carried out by the Supreme Administrative Court. Nonetheless, whatever the tribunal says, mainly whether it says that the law is unconstitutional or not, repealing the provisions that are flagrantly violating EU law and the rule of law issues, like, for instance, the fact that judges may be faced disciplinary proceedings for their judgments, that the content thereof have to be repealed. The second thing is about the change of the status and the change of the national Council of Judiciary. The problem with this council right now is basically that the representation of the judges in the council is appointed by politicians and not by judges themselves as it used to be before these reforms. And here again, the idea how to change it is very straightforward, but it would require the signature of President Duda under the draft, and the question is whether President does so or not. But again, I would be rather reluctant on the idea of bypassing this, and then, for instance, that is one of the ideas, that the law itself will not be changed, but so formally politicians will still be appointing the representatives of judges, but basically what they do would be just asking the judges to propose these candidates, and then these candidates will be and not others will be appointed. This is not the idea I'm advocating. And the last topic, which is basically the most difficult one, and no doubts about that. So what to do with judges who were appointed by the National Council of Judiciary in the wrong procedure, on the basis of wrong provisions, and what to do with judgments themselves. And even if there are some ideas for the further topics, so either to make a verification of disappointments, or basically to the most brutal, I would say, way, so to cancel disappointments. I think that this may be done. The bigger problem is with judgments, because it's hard to imagine that any law may basically cancel them. That would basically mean that there is an intervention of legislative power into judiciary, but most probably that would be some reopening procedure for some judgments, and we must the last thing, we must be conscious that there are some judgments which basically were beneficial for the parties, right? So basically they will not have an appetite for challenging them, even if they were issued in a wrong procedure or by wrong judges. Thank you.
Thank you very much. And the question to Dr. Petryshyn, would you like to react at this stage of our discussion?
Excuse me, I didn't hear that very well.
The question is whether you'd like to react at this stage of our discussion, or...
Yes,
great.
I would like to thank other presenters for their discussion, also concerning the questions I asked, and I wanted to reflect on the position of Mr. Klip on the advisory group of experts. It was quite a long time ago, but anyway, and possibly ask a question to Mr. Klip. In the current circumstances, I have concerns that in pursuit of political objectives, the work of the international advisors may be at risk of sabotage or neglect. Given that during the legislative process there were already attempts and manipulations associated with this matter. On the other hand, should the Ukrainian authorities maintain the state's interests and limit the influence of the international community in this regard? To what extent is this a viable strategy? I find that the whole idea is somewhat indicative of distrust in that national judicial corpus or established procedures are capable of providing qualified and ethically virtuous candidates. So the idea is that Ukrainians are incapable of relying on their procedures and require additional stages of independent decision making. What are your thoughts on this matter? Thank you.
Thank
you. Yes, please.
Thank you very much. Thank you. First of all, I would like to conclude concerning all speakers what was said. I think that the biggest challenge for not only Ukraine and Poland, but for all European countries is to make rule of law be independent of any politics, any politicians, in order not to misuse or abuse law. And I think this is the main task. And of course, there are many I would say backgrounds here, so we should take into consideration cultural aspects, sociological aspects, and also the public, the mood, the spirit of specific society in every country. So I think that definitely there is no one right answer to the question how to build, how to implement, consolidate rule of law in every country. So I think that really there are many factors that influence, but the most important, and I agree with Professor Tomasz Koncewicz, that actually the main actor here, it must be society. So society must realize that rule of law is really a value, and it is not a given. It is really a work, everyday work to implement rule of law, to struggle for rule of law. And it's not only the written declaration in constitution, but it's also the practice, the experience, and also society must be active in this process. Without society, it will be impossible, because there will be always temptation for politicians to abuse rule of law and to misuse law just to protect not public interest, not the interest of majority, but the interest, private interest, or any political interest. And concerning the question posed by Oleh Petryshyn, I would like to say that actually, I support this international advisory group of experts, because I'm not sure we had chance many times, but unfortunately, Ukraine did not manage to create any independent authority, and we see now the results. So I believe and I hope that this independent and independent authority, which consists of international independent professionals, legal experts, will really help us to be at least in the process of appointment of judges of constitutional court. Of course, I understand the matter of a national interest. So the key point here must be, of course, the defense of national interests. And actually, our authorities, Ukrainian authorities, try to preserve our national sovereignty, state sovereignty, and not to allow international experts in this sphere. And on the one hand, I understand, but I believe that it was misused under the veil of the concept of national sovereignty, just not to avoid international experts to participate in this competition. So I strongly believe that it is a good step. Of course, as I said, we will see the final results, but again, the second point here must be actually the the competition between, not the competition, but who will be actually these international experts. And as I know from Poland, because just recently we have already formed this advisory group of experts, and there are two representatives from Poland. It's former Prime Minister of Poland, Suchocka, and also Marek Zubik, former judge of the Constitutional Court of Poland. So they are now, they joined this advisory group of experts. And of course, it might be a concern maybe about, again, the national interest. So still this national interest, the national interest of Ukraine will be preserved in this process. And in this sense, of course, there must be a very strict and transparent procedure as well concerning these international experts. So the next question, who will be this international experts? So definitely they must be independent, and they must have this public support, not only public support from international community. And why? Because of the legitimacy of this authority as well. So again, there must be legitimacy of this authority. So in general, I think that it's a good step, and I'm looking forward for the results. And unfortunately, I must admit that Ukraine has not managed to create such independent authority. Thank you.
Mm-hmm. Thank you very much. Would you like Oleh to react? Yeah.
Just a minimal remark. I think that this is probably the main issue with us Ukrainians. We always are rushing for the fast and easy solutions, of which there are none. So yeah, I agree with your position. Thank you.
Mm-hmm. Thank you very much. And we still have a question in the chat for Professor Tomasz Koncewicz. This is a question by Angela Di Gregorio. And the question is how to connect practically the pre-accession rule of law conditionality with the post-accession one, elaborated mainly in the case law of the Court of Justice of the European Union. And maybe one more question also to Professor Koncewicz from my side. Because you mentioned on the relations between independence and accountability, and I would like to ask about the accountability. What form should judicial accountability take in order to contribute to public understanding of the functioning of the judiciary? And
okay, so
just the last question, do we have another questions? Otherwise, it will be the last answer. So there's still the possibility to formulate maybe one additional question, but I do not see also in the chat. So if not, yeah, I will give the floor to Professor Koncewicz.
Well, first of all, thank you for the chat question. And I believe it is based on the wrong assumption, because on May 1st, 2004, the distinction between pre-accession and post-accession conditionality and understanding of the rule of law loses much of its practicality, because once you become a member state, there is one understanding of the rule of law that is valid for all the member states of the European Union. And there is an assumption on the accession day that you accede to the European Union, we accept you as a member state because we think that you are good enough when it comes to the rule of law. But after the accession Big Bang, you have to show us that you can only improve on the rule of law. You will never regress. So that's why we are talking about this democratic backsliding, because the assumptions made at the moment of accession prove to be wrong, because there is a trend now of member states moving backsliding on their commitments made on the accession day. So the pre-accession rule of law was judged to be satisfied on the accession day, and post-accession, your rule of law becomes part of the European rule of law, and you can only improve on this commitment that you made on the accession day, but that you will never regress when it comes to the understanding of the rule of law. So that would be my my answer to this question. And when it comes to the accountability, right now, of the top of my head, I cannot think of a ready-made solution. But what really matters is framing the accountability discussion for the public. That whatever model we will choose, the accountability will be provided in a transparent and fair fashion, so that the people and the citizens can actually see that judicial independence is not just a privilege, but it is a privilege that is to be repaid with performance. And if you don't repay the privilege with your performance, there will be some sort of accountability. And I don't want to go into details of how it would look like in practice. Just framing, providing for a transparent procedure to make sure that judges will be held accountable when they should be held accountable, not for political purposes, but for professional decency, and for making sure that they are in line with the ethical side of their profession. So I believe the messaging comes first, and then the legislative solutions come second, in order to implement the messaging and the framing idea at the very start of our process.
I'm sorry. Thank you very much for this answer. I do not see another question, so I think that we can try to go to the end of our meeting. Thank you very much to all the speakers for the really interesting and valuable presentations. Thank you for the questions. Thank you for discussion. I would like also to add that we are going to organize the special seminar. Probably it will be in February, which will be devoted to the problems of the constitutional judiciary in Poland and Ukraine. So that the problems on the necessary changes required for the organization and functioning of the Constitutional Court in Poland, in Ukraine. And we would like to invite you to this seminar, although I'm going to send you also the special invitation, so there will be more detailed information. But for this seminar, I would like to really say thank you very much to all of you for joining, for being with us, for joining the seminar, for being with us. We are really grateful, and I hope that you also found, as I found, the discussion very valuable. I think that we managed to outline the main, just like to give the perspective for our further discussion, in order to discuss about the particular problems of the judiciary, of the Constitutional Court or Supreme Court in both countries. We need to have we need to know and understand the EU standards and EU understanding your approach to those problems. So that's why this seminar particular was highly important for us, and that's why I'm really grateful, especially to the presenters. So thank you again, and have a good evening, and hopefully to see you next time, probably in 2 months. Thank you very much.
Thank you very much.
Thank you.
Okay, so see you, Christina. We'll be in touch. Bye-bye.
Bye-bye.